Hi guys, it's Kathy. I hope you're doing well. Feels like it's been forever. Saturday morning to Sunday night. Okay, but we're gonna go to one docket tonight. I might take a break in the middle and show a clip for Josh. Maybe. We'll see. I don't know. This is Judge Cristofino in Indiana. You can only see him here. And he's very different than what we're used to. So this judge, he's very technical. So when you go before him, you are a number, you broke the law, and this is what the guidelines say, and this is what's going to happen to you. So he's not someone where if you mess up on probation, you get another chance to figure it out. He's not someone where, my mom's dying, my dog, no, that doesn't matter. It doesn't matter. He doesn't get to pick in his head. He doesn't get to decide what happens to you. You broke the law. This is what is said that's supposed to happen to you. This is what happens to you. So all the other stuff that other judges listen to and comment on and everything, no. Sometimes you'll see. Sometimes he does, but it's just rare. It's just you go before him. He says, this is your crime. F2 gets this amount of time. That's what you're getting. So, here we go. Judge Cristofino. I do so love watching Judge Cristofino.
Hearing. Ms. Bichkowski, okay, get rid of that phone. If it's in a yonder bag, get rid of the yonder bag. You bring that back in here and that phone's going to be mine. Any of you people got phones in yonder bags, get them out of here. Circuit Court doesn't have any phones in it at all. I was promised we were going to have.
So, yonder bag. You guys ever heard of a yonder bag before? Me neither. So apparently, some courthouses have these like lockbox things. You give them your phone. They put it in this bag, and then they lock it. And then they hand you the bag. Now you can take your phone with you to court. But you can't open the bag. You can't touch your phone. This judge is saying, if you have a yonder bag in my courtroom, you better get it out. Get cell phones out. Or they're going to be mine. I've never heard of a yonder bag before, but I feel as a parent with 3 kids, I should have had yonder bags. So if you're a parent with kids, go buy some yonder bags. They're going to love you.
This solved by December 1. We're now waiting on lockers for you to put your precious phones in. You're not going to need a phone in here, folks. I'm telling you that right now. All you're going to do is get in trouble. I apologize, Ms. Bichkowski. Mr. Johnson, I'm sorry. Phone went off. I'm very agitated by phones, particularly in circuit court. Let's get back to the competency part of this. Bichkowski, did you have a chance to look at the 2 evaluations from Dr. Chisholm-Buggs and Dr. Sibylla, respectively?
I did.
Are you prepared for the competency hearing today?
I am.
I have some questions I want to ask you and Mr. Pitzer before we go much further. First off, Ms. Bichkowski, may I make, as a part of this record, the respective competency evaluations of Dr. Chisholm-Buggs and Dr. Warren Sibylla Jr.?
Yes.
Mr. Pitzer, okay with you?
Yes.
So, counsel, may I treat that as an evidentiary stipulation on your part as to the competency of Mr. Johnson? Ms. Bichkowski, may I do that?
Yes.
Mr. Pitzer, may I do that?
Yes.
Ms. Bichkowski, are you willing to stipulate that Mr. Johnson is not competent at this time to stand trial.
I am.
Mr. Pitts, are state willing to stipulate?
Yes, Judge.
Court finds that defendant Eric J. Johnson Jr. is not competent to stand trial at this time. Court bases its decision on the respective competency evaluations of Dr. Chisholm Buggs and Dr. Warren Sabilla Jr. Court further bases that decision on the parties' evidentiary stipulation and their stipulation in court that Mr. Johnson is not competent to stand trial. Court further bases that finding on the fact that the court has observed Mr. Johnson in court on a number of occasions. And while there are times when he does seem to be able to follow the proceedings, there are other times when it is clear that he is not fully comprehending the proceedings. Court specifically finds that the defendant is not competent because he is currently unable to understand the present proceedings and to assist his defense attorney in his defense. Court orders that the defendant be transported to the Indiana State Hospital for restoration. Court will enter a separate order on this competency hearing. Ms. Beachkowski, did you want to make any other record?
No, Your Honor.
Mr. Pitzer, how about you?
No.
Josh, I have a clip for you in a bit, just for you.
Can I ask a question? Can I ask a question? Can I wait?
No, Mr. Johnson, because we're done with that part. I'm going to enter an order. Here's what's going to happen. We're going to send you to a state hospital so that they can try to restore you to competency. And under the law, if they restore you to competency, then you'll come back and I'll set your case for a jury trial and you can proceed to a jury trial, or perhaps you'll work something out with the state, but you can proceed. Right now, we can't do anything on your case until I have a doctor tell the court that you've been restored to competency. If you've got questions on this, I'm sure Ms. Beachkowski will answer those. All I'm doing is telling you what the law is, okay?
So when would I go to a hospital, you say?
As soon as they've got a bed open for you.
And Judge, if I may.
Yeah, go ahead.
Thank you. And I'm guessing, I think that's going to be my client. He wants to know when you're going to be transported. That is not an answer that I can give you. I don't believe the judge can give you that answer or the state. It'll be when a bed becomes available. They will let the court or the mental health clerk know in Elkhart County, and they'll transport you. But that's nothing that any of us here today have any control over.
And Mr. Johnson, I'm going to add one other part to this. I don't know where the state hospitals are at now. Sometimes this takes a while, but I just had one that they placed and it was just outside of 30 days. But I will stay on top of this and I'll get you placed as soon as I can, okay?
Okay, that's not terrible. I mean, some states are quicker. Some states take a lot longer than 30 days. He has to sit in jail for 30 days no matter what before they even start. Sorry, I typed wrong my hand. Thank you so much, John, for trying to raid me. I appreciate it.
So yeah, because I've been wanting to know what's going on for weeks now, months now. And the hospital in Indiana, right?
Correct.
Yes.
Correct. But I don't know which one it's going to be. There are several. Okay? Mark this. Cause coming on for competency hearing. Defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney, Andrew Bichkowski, also by WebEx. State of Indiana in court by Deputy Prosecuting Attorney Don Pitzer. Court conducts hearing on defendant's competency. Parties agree that the competency evaluations of Dr. Chisholm Buggs and Dr. Warren Sabilla Jr. may be made a part of the record of this competency hearing. Parties further stipulate that defendant Eric J. Johnson Jr. is not competent to stand trial. Court finds that the defendant Eric J. Johnson Jr. is not competent to stand trial and is not capable at the present time of understanding the proceedings or assisting his counsel in his defense. Defendant ordered, referred, and transported to an Indiana State Department mental hospital for restoration. Court will issue a separate order on the determination of competency and order for transportation. Court will set this matter for a jury trial and trial status conference upon the defendant being restored to competency. For purposes of Criminal Rule 4, all time is attributed to the defendant. It is so ordered. Thank you, Mr. Johnson. You're all done. Ms. Bichkowski, thank you. You can get on with your day.
Can I ask
Thank you.
I got one more question. So would the mental health people be able to come talk to me soon, or would you?
I can't answer that. We've already covered that, Mr. Johnson. As part of the not following what's going on. That's why we've got to get you restored. Okay, let's get you to a state hospital and see if they can't restore you. I'm fairly certain they're going to be able to.
They're not approving me for meds or nothing in here.
That's why we got to get you to a state hospital. That part you do understand. You need to be on medication. We got to get you to a state hospital. Okay.
All right.
All done today. Good luck.
Yeah.
All right. You don't have anybody else, do you, Ms. Bichkowski?
I don't. That was it. Thank you.
We're being rated by John. John, thank you so much. I appreciate it. Hi, guys. Welcome. If you're new here, this is Michael Cristofino. He is a judge from Indiana that you can only see here. So you get to see him. He's very strict toward, he follows the law, period.
Mr. Jones, can you hear me okay?
Yeah.
You can't hear Mr. Jones great at first, but don't worry. Mr. Judge Cristofino takes care of that right quick.
Hang on a minute. (20C01 2512 F117) State of Indiana versus Devontae Jones. Mr. Jones, raise your right hand. Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Yes.
State your name for the record.
Devontae Jones.
Thank you. You can put your hand down. Show the defendant appears in person as a self-represented litigant. State of Indiana in court by Deputy Prosecuting Attorney Don Pitzer. This matter comes on for pretrial conference. So, Mr. Jones, a couple things. Number one, you told me you were going to hire private counsel. I see that you have no private counsel. The gallery cannot talk. So where are you at in hiring private counsel?
I think, I don't know if my mom in court, I can't really speak, but I think my mom should be in court. She can explain it better.
Yeah. Okay, your mother is in court. She can't represent you. She can't speak at this hearing. So I'm going to ask you again, where are you at in obtaining private counsel?
Payment.
What?
like paying the lawyer.
I can't understand what you're saying. Speak up and speak clearly.
Oh, paying the lawyer.
Yeah, well, no lawyer has entered their appearance. So here's what my thought is, and you have rejected this before, and I'm about to the point where I don't care what you say. I'm going to be really clear on this. You're facing a level 1 felony and you have no attorney representing you. I cannot tell you how bad that is. It's bad, but I don't think I can make you appreciate it. It's bad. I've also told you this. I can appoint a public defender to represent you the moment that your family gets enough money to hire private counsel and private counsel appears. I can assure you the public defender's office will be withdrawn. That appointment will be withdrawn and you'll have your precious private counsel. But at least, Mr. Jones, in the meantime, you'll have somebody looking out for your rights besides you. And if you think that I'm wrong on the conclusions I'm drawing, well, I would just point out to you, I entered an order that you weren't going to be transported out of Elkhart County. Where are you at right now? Aren't you at Pendleton at the juvenile DOC?
Yeah.
You know why that is?
My juvenile charge.
You what?
My juvenile charge.
Yeah, because that's not it. Because you caused so many problems at the juvenile detention center, they couldn't control you. So they sent you down to Pendleton Juvenile DOC. Now, whoever your attorney is, they're going to have to communicate with you through Pendleton. You've made things much harder on yourself. And I tried, here we go again, Mr. Jones, the judge trying to protect you from yourself. You know, I guess I should start listening to the Supreme Court. They tell me that's a bad idea, and
So he did, when this guy came before the judge before, the judge tried to give him a lawyer, and he said, no, my mom's gonna get me a lawyer. Well, mom hasn't got him a lawyer yet, because he hasn't been paid. The lawyer hasn't been paid. And the judge told him, I will give you a lawyer now, no problem. And then when you get a lawyer, we're just withdraw this one. And they said, no, we're getting a lawyer, no. This is Judge Michael Cristofino. You can only see him on this channel. He's from Elkhart, Indiana. I'm pretty sure Elkhart, but you know what? If I get the county a little wrong, sorry, I don't live in Indiana. He's Judge Cristofino. So you notice what he said right there. I should have listened to the Supreme Court. I'm telling you, when this guy gets a directive, he follows it. He does not care. I think his mom might have pushed him to do differently last time.
can't do it. They tell me in the Constitution I can't do that. I have to just let you make bad decisions. I would bet you this, if I could talk to your mother, I tell you what, I bet if I could talk to your mother, I bet your mother and I would be on the same page. Because your mother certainly cares about you. And all I'm trying to do is get you in a position where you've got some legal advice being given to you and somebody's looking out for your rights besides you. Because from where I'm sitting, you're doing a really bad job. Now, do you want me to appoint a public defender to represent you?
Yeah.
I think that's a good idea. Let's ask you some questions. I'm going to make sure you qualify. Own any real estate, like a house?
No.
Okay. Do you own any personal property, like a car that you could sell?
No.
Do you have any cash, any investment accounts, any bank accounts?
No.
Are you currently employed?
No.
Jones, how old are you?
17.
Court finds the defendant to be indigent. Appoints the public defender's office to represent the defendant. I don't know who your public defender is going to be. I appoint the public defender's office. Mr. Majerick will assign somebody to represent you. He's the chief public defender. He'll assign somebody to represent you. That deputy public defender will be your person. It may be him. He may say he's going to take the case. We'll see. Okay, I want to confirm some dates because I'm going to consider this to be the pretrial conference. When you get private counsel, they can ask for a status conference. If the public defender's office gets involved and talks to you and you don't hire private counsel, they can get a status conference. But we're going to go over these dates. So your jury trial is scheduled for April 6, 2026 at 8:30 a.m. Do you acknowledge that jury trial setting on the record?
Yes.
You understand if you don't show up for that jury trial, I'll hold the jury trial without you?
Yes.
Here's the other date I want you to take in. Your trial status conference is confirmed as March 12, 2026 at 8:30 a.m. Now,
All right.
Mr. Jones, because I've appointed the public defender's office, so you're going to have representation. Is there anything else you want to address today, though, while you've got me? Anything else you want to address? Because I might not see you again March 12.
No good.
Okay. Mr. Pitts, anything you want to do at the pretrial conference?
No.
Cost coming on for pretrial conference. Defendant appears in person from the Juvenile Indiana Department of Correction at Pendleton, Indiana, as a self-represented litigant via WebEx. State of Indiana in court by Deputy Prosecuting Attorney Don Pitzer. Court conducts pretrial conference. Defendant acknowledges jury trial setting on the record. Court confirms the trial status conference date. Defendant requests appointment of counsel. Defendant examined and found to be indigent. Public defender's office appointed to represent the defendant. It is so ordered. Mr. Jones, thank you. You're all done.
Appreciate it.
You can sign out. Go off a second. Christian Gomez, can you hear me?
Yes, Your Honor.
Great. Mr. Majerik's here in court with me. (2001) 2303 F27. (2001) 2501 F31. Both State of Indiana versus Christian A. Gomez. Mr. Gomez, raise your right hand. You swear affirm under the pain, space, perjury that the testimony you're about to give will be the truth?
Yes, Your Honor.
State your name for the record.
Christian A. Gomez Benitez.
Thank you. You can put your hand on. I see that on one of these it's Christian. It's both in both of these. I apologize. It's Christian Gomez Benitez. I apologize. I only had part of it written down.
So guys, if you want John's link to his channel, I just threw it in chat. Check it out.
Okay.
That's my staff's fault. I don't type, so you know I didn't type it out. It's good case stuff.
Sweet dreams, CJ. I love you.
A cause coming on for trial status conference. Defendant appears in person from the Elkhart County Correctional Facility via WebEx by his attorney, Chief Public Defender Jeffrey Majerek. State of Indiana in court by Deputy Prosecuting Attorney Don Pitzer. Again, this matter comes up for trial status conference. Mr. Majerek, go ahead.
I did meet with Mr. Gomez Benitez the other day. This was pushed over from last week to give me that opportunity. He and I are in conversations. I need to have more conversations with Ms. Clays. We're asking that we can kick the next hearing out a bit. I think it's set for trial.
It's set for trial February 16. Do you want to continue that jury trial?
Yes,
setting?
we do, Your Honor.
I'm not trying to tell you what to do, Mr. Majerek. You're very versed, and you've been practicing law longer than I've been an attorney. I'm just thinking that would give you more time.
And I think we're
work out a plea.
I think we're moving in that direction. He's not going anywhere. He's got an ice hold, so he's still going to be probably where he's at for a while.
I was well aware of that, but I'm going to bring that up. Any objection?
No.
Okay, Gomez Benitez, your attorney wants to continue your jury trial. And this just is the way it falls now because April is a bad month. Your next date would be May 4, 2026 at 8:30 a.m. Is that what you want me to do?
Yes, Your Honor.
Are you therefore acknowledging on the record that your new jury trial setting?
Shut up, JK. Oh, wait, no. Thanks, JK. Thank you so much for the gift memberships.
Is May 4, 2026 at 8:30 a.m.
Yes, Your Honor.
You understand if you don't show up for that jury trial, the court's going to hold the jury trial without you.
Yes, Your Honor.
So if you want to tell your side of the story, you want to call witnesses, you want to present evidence, you need to be in court for your jury trial on May 4, 2026 at 8:30 a.m. Do you understand that?
Yes, Your Honor.
Trial status conference is going to be April 9, 2026 at 8:30 a.m. You need anything else, Mr. Majere?
Not with regards to, Christian.
Cause coming on for trial status conference, defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney, Chief Public Defender Jeffrey Majere, State of Indiana, in court by Deputy Prosecuting Attorney Don Fitzer. On motion of defendant, jury trial continued from February 16, 2026 to May 4, 2026 at 8:30 a.m. Defendant acknowledges jury trial setting on the record for purposes of criminal reform, all time attributed to the defendant. Trial status conference scheduled for April 9, 2026 at 8:30 a.m. It is so ordered. Thank you, Mr. Gomez Benitez. You're all done.
Your Honor, if I
Thank you.
may. We do Mr. Williams, Christopher Williams. I have,
Sure.
please, I'm going to go out and do it to jail momentarily, and he's not in custody.
Look, we can see Mr. Pitzer. Oh, wait. We don't want to start him yet. We need time for him. Let's take a field trip. Can we just take a field trip? So, this next clip, I'm going to come back to this one. Don't worry, we're not even close to done. This next one's for Josh. It's pretty quick. It won't take long. And it probably won't even be very funny until
Let's go ahead and
the
call
end.
26M 5001, People versus Joseph Thompson. Mr. Thompson, my name is Judge Scott. I'm the bond hearing officer this weekend. I will not be the judge in your case moving forward. It'll be handled by the local judges there in Routt County. These proceedings are being recorded. They're also being live streamed on the internet. Mr. Santalaria is our defense lawyer here today. Did you have a chance to speak to him either yesterday or this morning?
Hi, Val.
I talked to somebody last night, but I don't believe that's who it was.
Okay. Would you like
Well,
that?
it was who it was, just FYI.
Well, it was? Okay, sorry. Okay. I trust you want Mr. Santalaria to represent you here this morning?
Yes.
Okay, I do appoint him for today's proceedings. Sir, if you're released on bond and you want continued representation by court-appointed counsel, you'll need to fill out the public defender application and qualify by the state's financial guidelines. You also have the right to represent yourself or to hire a private attorney. Do you understand that?
I do, Judge. Thank you.
Okay. Mr. Santalaria, do you waive further rating and advisement pursuant to Rule 5?
We waive advisement.
Okay. What we're going to do at this point, sir, is we're going to determine the scope of a protection order that's appropriate, and then we're going to set your bond. I'm going to hear first from Mr. Bucci from the District Attorney's Office. You may go ahead, sir.
Your Honor, in regards to the protection order, we'd ask for a full no contact order, including no firearms, no ammunition, relinquished any of those items, no alcohol. I believe this is based on the facts and the alleged in the affidavit, an offense of domestic violence. As to this defendant's criminal history, Your Honor, out of the state of Colorado, he's a 2017 driving under restraint conviction for which he was sentenced to 60 days in jail. He's a 2019 misdemeanor criminal mischief, domestic violence, which he was sentenced to probation and 30 days in jail. That was a different victim than this case. He's a 2024 petty offense trespass conviction. Out of the state of Wisconsin, he's a 2012 felony aggravated battery and misdemeanor theft convictions for which he was sentenced to 2 years in probation. He's a 2014 operating while intoxicated, their equivalent of a DUI, 20 days in jail. 2016 misdemeanor possession of cocaine conviction. The 2025 misdemeanor disorderly conduct conviction, 1 day jail. That was from November of this past year. He has one failure to appear from 2018. Your Honor, based on the defendant's criminal history, previous domestic violence convictions, pretty substantial criminal history, including recent convictions from 2024 and 2025. People would request a cash or surety bond between $2,000 and $4,000. As to the victim's position on bond, she didn't have one. Thank you.
Thank you, sir. Mr. Santalaria?
So we are still talking about property damage here. This is not, I know it's classified as act of domestic violence, but there was no
violence here. It was just a property damage, the allegations of a door latch being broken or something like that. So relatively minor, all things considered. And I do understand there's a bit of history here, but he
What?
does have strong ties to the community. There are no FTAs.
Josh, are you okay? A lock was broken, Josh. In this case, a lock was broken and damaged. He should be in jail for that lock being broken. Josh, breathe through it, okay? The lock is broken. It's gone. It's dead. Josh is a locksmith, guys.
He is employed in Revokes County in Steamboat. He's got a couple different jobs. He does some window cleaning, snow removal, and some other things. But strong ties to the community. It's not a risk not to come back to court. And given the relatively benign nature of the allegations, I think a PR bond is perfectly appropriate.
Okay, I do find a protection order is appropriate pursuant to 18-1-1001. The protected party is Emmanuel or Emma Mortensen. The court does find the probable cause act affidavit includes an act of domestic violence pursuant to 18-6-800.3 subparagraph 1. The court further finds this is a victim's rights case. This is borderline Brady case, but
this is a victim's rights case. This is borderline Brady. Josh, you're right. Locks are very important, guys.
The court's going to order the firearms restrictions anyway by virtue of the nature of the initial call with the threats of self-harm. The court thinks that's in everybody's best interest in this case. It is ordered as the terms of this protection order, sir, that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing.
Whoa, throw some extra locks in there. Don't break the locks of your neighbors or your family or your friends or any business. Stay out of Fulton County.
You shall vacate the home of the victim, stay away from the home of the victim, stay away from any other location the victim is likely to be found, specifically 2670 Copper Ridge Circle, number 19A in, I guess that's Copper Ridge Circle, number 19A in Steamboat Springs, Colorado. You may not contact or communicate with the victim either directly or through third parties, and that means no contact in any form. That means no in-person contact, phone calls, emails, text messages, social media, Facebook, FaceTime, Instagram, Snapchats, WhatsApp. No contact means no contact, either directly or through third parties. Once again, based on the circumstances of your case, you shall not possess, purchase, or control a firearm or other weapon. You may not possess or purchase any ammunition. Shall relinquish for the duration of this order any firearm or ammunition in your immediate possession or control, or subject to your immediate possession or control, and you shall do so within 24 hours of your release, excluding weekends and holidays. You shall also file the firearms relinquishment affidavit and file with the court within 7 business days. You may not possess or consume alcoholic beverages or controlled substances without a valid prescription. This order will remain in effect until final disposition of your case or until further order of the court. Violation of this order is punishable as a Class 1 misdemeanor by up to 364 days in jail and up to a $1,000 fine. It's also punishable by contempt proceedings.
I've sold my carrier pigeon 23 times on Facebook Marketplace. If I had one, if I really and truly had one in real life, I would have sold my carrier pigeon 23 times on Facebook Marketplace. And if you want to learn any other great ideas on how to make money online, just send me $19.99 and I'll show you how. Okay. Josh, I hope that the punishment fit the crime for you. He's got so many bond conditions for breaking that lock. And gosh darn it, he better know better next time. All right, back to Cristofino and this guy. Oh no, it did it again. Oh, and that's my fault for thinking I could just press play and my shit's gonna work. Sorry. Son of a gun. Okay. Oh, brother. All right.
competency hearing.
I
Ms.
know,
Witkowski?
we already saw this.
Okay. Hearing.
There we go. Now play. Oh, it's playing. Yes, sir.
Okay,
I
so
am
I'm
a
not seeing him.
professional
You see him?
YouTuber,
He's
guys.
on my calendar for
Wrong
yesterday
button.
in front of the magistrate. And then again, he's on my calendar for today. However, the magistrate didn't know anything about the case up here. And they used to, I think at one point, all be on the same page, but now they've kind of split out. The one that we had or the one that I had that she didn't have was the F6, I believe.
Oh, I'm going to Fulton
She had both
County.
the misdemeanors on
I'm gonna
her
find out
calendar.
who
So
did
she
this.
kicked it out to,
What is the other case, the level 6?
yes,
That, I can't guarantee it's gonna be in front of the magistrate, but most likely it is. And the reason I can't guarantee it is because some of these, well, I'll just be candid. It was easier to just schedule it on Thursday and do the level 6 hearing in front of me than it was to get it in front of Magistrate Monroe. Didn't have anything to do with anything else. I don't think he's set this morning. And if I had to guess, did you see, were you in front of the magistrate yesterday?
he thought he was supposed to be here today.
No.
I was in front of the magistrate yesterday and he was on her docket, but she didn't take any action. She said, we'll just keep it on her dates. Yeah,
So she reset it to her dates?
yes,
You're gonna be in front of her.
he does have a summons to appear here today. So I don't know why it's not. This is, let me make
Bill,
sure I
stop
have
spamming chat.
And actually, the summons is 2601 CM number 4 for here today. So there was, I'm trying to work it out with the magistrate to get them all on the same page, but would you like me to approach with this or?
Take me with you next time. You won't get carjacked. Your audio is fine. He's trying to figure out what's going on. I thought I cut this out. Nope. It's not fine. Oh, there we go.
I can have.
Is this your last one?
Yeah, I can have Mr. Johnson finish this up since it's not gonna be like.
No, forget it, Bill. Don't take me with you next time. It's 11 hours away. I'm not driving 11 hours so that you don't get carjacked. No. Drive a different car. Kelly, thank you for the cheers. I really did cut out a terribly lot amount of from this docket. I thought I got this. Casey Carey, hi love. He's stopping us from seeing it, but he doesn't know the camera's pointed right at him. That's okay. I'm going to fast forward a little bit.
John Machizik, State of Indiana, in court by Deputy Prosecuting Attorney Don Pitzer. This matter comes on for hearing on alleged violation of probation. Now, Mr. Machizik, go ahead.
Thank you, Your Honor. Your Honor, we're going to ask for something a little bit unusual today. We would like to ask for this to be put over a week and that the defendant be released today on a $500 bond. And if I can explain, if you'll indulge me for just a moment. Mr. Green his violations are drug use and,
Let me ask you a question. Have I got an IRAS report?
no.
I can't release him under the law if I don't have an IRAS report. You want a bond report?
Would I like to ask for a bond report?
That's how I get an IRAS score.
Okay. No, we're gonna be back next. Either, we don't have time for that today, obviously. And, so can I just explain to you what's going on?
You can, but what I'm telling you, the law is, listen up, Mr. Green, here's the law. You know, I always follow the law. I can't set a bond in your case if I don't have an IRAS PAT score. I don't like that law, but I'm not the one who made it.
Yes, Your Honor. What's that?
They probably, I don't know. Is the theft in Elkhart? No, it's Marshall County. You can look it up. Your Honor, I apologize.
It's okay.
That's my ignorance.
I don't want to hear about IRAS right now, please.
Mr. Green is, probation is recommending that, well, they say that they would not be against a community corrections placement if approved by the court. And this is in the first supplement.
Is he eligible for placement?
Yes.
Yes. McBurney is Fulton County.
Does he have any pending charges?
No.
And
he is, we're waiting for the evaluations from ECCC
got it. Okay.
and MCC. And I'm told we will have those either tomorrow or Monday. So
if we said over a week, we'll have those.
Yes, Your Honor.
Yeah, well, that makes sense. Keep talking.
And the reason, yeah, unfortunately, the reason we were going to ask for him to get out is because he's a disabled veteran. He has had a hernia from Afghanistan. The mesh has ruptured, and he was going to have an operation Monday, which didn't happen because when he was released
Did he
from,
miss the operation?
he missed the operation.
I would have furloughed him. I would have furloughed him on medical. I can do that without an IRAS deal. Mr. Green, I would have furloughed. Look, I've had that. I don't want to go into too much of my medical history, but I've had that. It can be excruciatingly painful. I would have furloughed you out to have that surgery done without question, without any question.
I've been asking, because I have a hematoma that acquired in my scrotum with the hernia mesh, so my intestines go into my scrotum. It's about the size of a grapefruit.
Yeah, don't tell me anymore. You're gonna,
That's almost half as bad as poor Bill suffering in Florida with cold weather. Florida. While I'm sitting here in Pennsylvania talking about Bill being cold in Florida.
I think I'm a doctor when I'm not on the bench. Don't tell me anymore. Have you got another doctor appointment or another surgery?
My wife contacted the surgeon as they said they can't do it. They can't schedule it since unless I talk to them myself. But they also told her that if I come into the emergency room in Plymouth, which is where the surgery was scheduled, that they could do emergency surgery. That's why I was going to see if get out today, I'm going straight to the ER from here. Because now I have another hernia acquired that popped out of my belly button.
Have you talked to anybody at the jail? Do they know that you need to be transported to Plymouth for
When I came here from Marshall County, the paperwork came with me, and I talked to the doctors, and they said that they would see what they could do about it. And I had my wife contact the hospital, and they said that Elkhart County canceled the surgery, which was the 26th. And that's when she talked to him about rescheduling another one. They said due to HIPAA law, they can't talk to her about it. But if I come into the emergency room, they'll have emergency surgery.
Your Honor, can you furlough him until next Thursday so he can get this arranged?
Well, no, he's going to have, but he's going to have to be transported by Elkhart County to have that done. Just hang on a minute. Go off, get off.
He made a bunch of phone calls. It took like I don't know, 10 minutes till he came back on. He's going to tell him how to get around this
Refer you
law.
just for a minute, or recess just for a minute. Just hang on a minute. I'm off the record right now. Don't say anything, Mr. Machizo will get all upset. Just wait.
Judge is going to tell him how to get around this, but no one's going to listen to him. They're bringing him papers and stuff to sign, but that's not what he needs. If he's in custody, he doesn't have to pay for an ambulance. He doesn't have to pay for treatment, right? Right? If you're in jail, you don't have to pay for treatment, right? Or will they still bill you when you get out of jail? You get all these medical bills. I also think Elkhart is close to a different state where one of that hospital might be closer.
Don't go on yet. Hey, Mr. Green, here's what we're gonna do. I usually do this not from the bench because it just doesn't work well to do it from the bench. I'm gonna have what's her title? Office manager? My Grand Poobah, Laura, is gonna call, Grand Poobah S is gonna call the jail and see if we can work out, if I do a medical furlough, if they can transport you to Plymouth Hospital emergency room for
Okay.
surgery, okay?
Thank you, sir.
Yeah, we'll see what date that's gonna be, because that's gonna be a lot quicker than me getting an IRAS PAT score. And I can do medical furloughs, that comes under the heading of emergency. You know, whether anybody else thinks it's emergency, I think you and I do, so
Yes,
that's
sir.
probably good enough. And then we'll do some of the other, but I'm gonna recess, I don't want you to leave the area down there, but I'm gonna recess your case until I get word from the jail on what they wanna do. And
Yes, sir.
we may have to do this differently, because we may have to just handle something now, and then I'll talk to the jail when I get off the bench, all right?
Yes, sir. I also told him if they have to do like an ankle bracelet or whatever, I can pay for that. Like the monitor, like a pretrial release bracelet until
Yeah.
Dude, shut up and listen.
I can pay the setup fee and the weekly payments or whatever it is for that until we come back to court.
Yeah. But let's try it my way first, because
Yes,
my
sir.
way, I'm not gonna get in any trouble.
Yes, sir.
I
Thank
know
you.
I'll be. We're gonna get back on in recess in a minute. You got anything else you wanna add right now? I mean, I really think we need to find out if it seems to me it would be the simplest if I just entered a medical furlough. They don't have to stay with him. They gotta transport him down, they gotta transport him back.
That would be great, I think, Your Honor.
He listens to you like he
I don't have
listens to
anything
me.
else, but I can stick around, or I can be right down the hall. If you need me back.
Stick around a little bit. Let's see what's gonna happen, because I don't think it's gonna be that long. Let's go back on. This is State of Indiana versus Craig S. Green Jr., 20 CO 11812 F5 366. We're back on the record after a short recess wherein we discussed some medical attention that Mr. Green needs. And the court is having staff contact the Elkhart County Correctional Facility to determine if we have a resolution for that medical treatment. So we're going to recess this hearing and we'll take it back up today yet this morning. Mr. Green, don't go too far, okay? Don't get out
Yes, Your
of,
Honor.
they'll let you, don't get out of earshot. Just tell them we're on recess, but you're going to be back in. And then I'll take Terry Lean next, okay?
Yes, Your Honor. Thank you.
So basically, he told the guy to have an emergency. Have an emergency, and I will sign the medical furlough once you're released. I do it all the time. When there's an emergency, stop trying to schedule this the correct way. Go to the emergency room and get the surgery.
Excuse me. Can you hear me?
Yes, sir. Yes, Your Honor.
Mr. Johnson is here with me.
Which means it's free. Right, John? Free? What if you're just in jail and not prison? Then is it still free? Let's say I need something that costs 60.
20C01, 2401 F5.
Judge, I am speaking. Rude. This is my courtroom. Let's say I have something that would take $45,000 to fix. You know, like one ambulance ride. If I'm in jail, not prison, but jail, do they pay for that? Is it all paid for if I go to the hospital when I'm in prison?
20, State of Indiana versus Terry G. Lean. Mr. Lean, raise your right hand. Do you swear or affirm on the pains perjury that the testimony you're about to give will be the truth?
Yes, sir.
State your name for the record.
Terry Grady Lean.
You can put your hand down now. Thank you. Should
Substandard care is great care if you don't have care.
the defendant appears in person for the Elkhart County Correctional Facility via WebEx and by his attorney, Matthew Johnson. State of Indiana in court
My
by
sister too,
Deputy Prosecuting
John.
Attorney Don Pitzer. This matter comes on for an alleged hearing, a violation hearing. And Mr. Johnson, go ahead.
Thank you. Mr. Lean would like to admit his violation.
Mr. Lean, before the court can accept your admission, I must be certain that you understand your legal rights. The state must prove any alleged violation by preponderance of the evidence. You're entitled to have a trial in open court just as you're having right now. You're entitled to be represented by an attorney at all stages of the proceedings, just as Mr. Johnson is representing you now. You're entitled to confront and cross-examine any witnesses that testify against you. You're entitled to subpoena witnesses at no cost to testify on your behalf. You cannot be forced to testify against yourself regarding new criminal matters. As to all other matters, you can be called to testify against yourself at the trial. Are you telling the court that you understand your legal rights, you're waiving those legal rights, and that you're admitting that you violated probation without a trial?
Yes, Your Honor.
Factual. Go ahead, Mr. Johnson.
Thank you. Mr. Lean, you were to report to Elkhart County Probation within I'm sorry. I guess we'll go with this one. Mr. Lean, you were on probation in this matter, correct?
I just been released from prison and
Right. You had just been released to prison, but after being released from prison, you were under the terms of Elkhart County Probation, correct?
So if I ever pass out on stream and one of you MFers call an ambulance, I will find you. Never call an ambulance for me. Never.
Yes, I haven't made it there. Yes.
Yeah, you just hadn't made it there, and we'll get to that in the sentencing. But while you're under the terms of probation, you are not allowed to commit new crimes, correct?
Yes, sir, Your Honor.
And
Yes, sir.
you were convicted in Whitley County of possession of marijuana, correct?
Yes,
And you pled guilty there on December 2nd, the day after you were arrested, correct?
yes,
And for that you did you were sentenced to 30 days, so you did 15 days in Whitley County Jail, correct?
yes, sir.
Okay. And one of the other terms is that you're not allowed to possess any illegal substance, and you agree that you possessed marijuana, correct?
Yes, sir.
Okay. And you also were not permitted to leave Elkhart County. Now, you never made it to Elkhart County after being released from prison, but one of the terms is to not leave Elkhart County, and you did go to Whitley County, correct?
I got released from Stark, and then yeah, I never made it to Elkhart, yes.
Went to a county that wasn't Elkhart, and you didn't have permission to do that.
Yes.
Okay. Nothing further on a factual. Any questions, Mr. Pitzer?
I do.
Okay.
Sir,
So
I show that
you have insurance, and the ambulance ride was $2,700, and you have insurance.
the sentence you got in this case was consecutive with some other cases. Is that correct? In Stark County?
Yes.
Okay, what were those cases?
2 F5.
What was the charge?
Handgun.
I see 3 cases.
New business idea, guys. Come on, guys. We all put our money in to buy some ambulances and hire some type of certified professional to throw in the back seat. They don't need to be a certified professional to be a driver. Okay? But the person in the back has to have some type of medical. And then we just charge $100. We'll get you to the hospital, but it has to be $100 cash on site, or you got to call an ambulance. We'll be rich.
An F529, F524, and an F597. Those were 3 separate and distinct cases, correct?
Yes.
And I'm sorry, tell me again what the charge and the conviction was on each.
The conviction charge in South Bend, I believe, was for a pistol.
Was for what?
A pistol. A handgun charge?
Yeah, pistol. I got you.
And you're
Sorry.
saying that was in South Bend,
Yes.
but you also had convictions in Stark County.
No, I haven't been convicted.
He has pending charges in Stark County. I think that if you look at the under the recommendations portion of the probation violation, it shows that those are still technically pending.
But you do have a conviction for the firearm, correct?
Jude, you're
Not
the
in Stark
greatest
County,
nurse ever.
but in South Bend. Yes.
Jude.
Okay, thank you. Those are all my questions.
So I've got just one area I want to talk about.
I have an area I need to talk about too within our end. I have a rash. Just kidding.
Did you ever make it to Elkhart County to report to probation?
No, sir.
And that's because you were arrested in Whitley County?
Yes, I was on my way to Elkhart, but I got pulled over and they have found a THC pen on me. And they have arrested me. Then, yes.
Got it.
I feel we don't have to follow those rules, Kelly. Not if we're just a transport service that, like, someone pays $100 cash to. I feel rules like that might be beneath us. We'll get you to the hospital for $100 cash, but you can't report it.
Court finds the defendant waived his rights, including his right to trial, and admitted violating probation. Court specifically finds that the defendant failed to timely report to Elkhart County probation and committed a new crime, that being possession of marijuana. I'm not going to find, Mr. Lean, that you violated by traveling to Whitley County, because you were never in Elkhart County to leave Elkhart County to travel to Whitley County. That's just not right. I mean, look, I'm not condoning what you did, Mr. Lane. You get out of the DOC and you go to Whitley County instead of coming here. That's a violation. You commit a new crime. That's a violation. But you didn't leave Elkhart County to do it. You left Stark County to do it. So the bottom line is you still violated. Based on those two findings. You want to do disposition?
Yes.
Arguments, go ahead.
Thank you, Your Honor. Given that there are, and the reason that we're doing this this soon is because there are limited options here due to pending Stark County matters. Mr. Lean has been released in those Stark County matters due to what he says is due to CR4 issues. He possibly has a CR4A issue.
So that was pretty important because we get that a lot. We get these cases where they get sentenced, okay? But first they have to serve like 2 years in jail and then they start probation. Or something happens, they get sentenced, something happens, and then they start probation. Like they have to go through treatment and then they can start probation. Or, whatever. They have to do this first and then they start probation. This guy right here was in jail somewhere else. In a different county, a different state, I don't remember. And then they released him. And he was driving to Elkhart to his probation officer. And he broke the law. So probation didn't technically start. I've seen when they are incarcerated and they have not started probation yet, but they get into a fight or something like that, that is a violation of their, some judges say that is a violation of their probation. I've seen someone who was incarcerated and they went to treatment and then they assaulted the staff at the treatment center. That is not a violation of their probation. So it all depends on what judge, what state.
Actually, because they didn't pick him up. He was in it while he was in custody in the DOC. So there may be some major issues in those Stark County cases. But what they're certainly doing is holding up his ability to do alternative placement. So what we're asking the court to do is to show the time that he served as a sanction and to put him back onto Elkhart County probation. Mr. Lean was out for 4 days. He started that by being released from Stark County jail and having to walk from there. He walked from Stark County all the way to St. Joe County, where he ultimately was able to meet up with his brother to get some clothes and a vehicle in order to try to get himself. He knew he needed to get to Elkhart County. That being said, he did go down to Whitley County, where he was ultimately pulled over, and there was a THC pen on him. He pled guilty immediately to that, and he got the 30-day sanction sentence, I guess. He's currently been in our jail since December 11th, so he has almost 2 actual months in. If the court is willing to allow him to go back onto probation, or to really start probation, he does have a good place to go. He'd live with his brother, and he does have a job set up for him already at Lippert, and he's planning to go to Oaklawn for his addictions issues. Mr. Lean, while he's been in Elkhart County Jail, he's making good use of himself, in that he's working in the kitchen. I think that he's a guy who's willing to work, willing to do the things that he needs to do. He was in a bad situation when he was let out of jail and made some wrong decisions. But I think that if he were released from Elkhart County Jail, he wouldn't be in a position where he'd have to walk tens of miles at very least, in order to get things set up for
But
life.
I would walk
So
500 miles.
we're asking
and I
the
would
court
walk
to
500 more.
show his time served as a sanction and to allow him to go back on probation. Thank you.
Thank you, Mr. Johnson. Mr. Pitzer.
Thank you, Judge. I have a number of concerns I'd like to bring to the court's attention. This looks like an individual who's committing crime in multiple jurisdictions. So he's been in St. Joe County, he's been in Stark County. When I look at these 2 pending cases, that 2208 F524, unlawful carrying of a handgun with a prior conviction, unlawful use of body armor, that's a concern, unlawful possession of a syringe, resisting law enforcement, disorderly conduct, and possession of paraphernalia. So that's pending. To the extent that there's an issue with CR4, I don't know what that is, but I know that the case is still pending. When I look at the other case that's pending, 2208 F529, burglary, theft, unauthorized entry of a motor vehicle. Somewhat interestingly, and I don't know, maybe somebody else could clear this up. When I look at this 92 DO1 2512 CM 1379, the incident nature says theft. Then it's possession of marijuana. So I don't know if they didn't charge the theft, but that's a concern. It would seem like one of the best ways to get these other cases resolved is for him to be somewhere where he can easily be found. I also note that the probation department is recommending a revocation.
Thank you, Mr. Pitzer. Mr. Lean, I'm going to let you give me a statement if you want to do so. Go ahead.
Okay, now guys, you got to remember this judge only cares about the strictest law that's in front of him. This guy never made it to probation in Elkhart County when he picked up this case. Just remember that.
Yes, sir. I've been released from Stark County to walk. My brother had come and got me. He lived in Whitley County. The theft, I don't know what that was about. They had dismissed it. I had to go to Whitley County to get my clothes. He was offering me a ride from Whitley to Elkhart to check in for Elkhart. So on my way to Elkhart, I had gotten my clothes and I had THC pen on me, and they had found that and charged me with that. I messed up. I had plans when I got out. I have better plans now. I plan on making a better plan for myself more as I go along. I already have a job set up, lined up. I have a place to go, and I have plans to go and put myself into Oaklawn for my drug issues.
Thank you, Mr. Lean. Excuse me. Cause coming on for hearing on alleged violation of probation. Defendant appears in person, excuse me, from the Elkhart County Correctional Facility via WebEx and by his attorney Matthew Johnson, State of Indiana, in court by Deputy Prosecuting Attorney Don Pitzer. Defendant waives his rights, including his right to trial, and admits violating probation. Specifically, the court finds that the defendant committed a new crime, possession of marijuana, for which he was convicted, and he also failed to report to Elkhart County probation in a timely manner. Court hears arguments from counsel. Court hears a statement from the defendant. Court revokes the defendant's placement on probation and reimposes the remainder of the 2-year sentence to the Indiana Department of Correction, Elkhart County Court Services, that would be probation, ordered to provide the court with a credit time memorandum. Court will award credit time upon receipt of that credit time memorandum. Bond, if any, is hereby released. The Public Defender's Office appointment is withdrawn. The order of commitment is entered, and the defendant is remanded to the sheriff to carry out the executed sentence. The sentence in this case will be mandatorily consecutive under Indiana law to any cases pending at this time. It is so ordered. Mr. Lean, good luck to you. Keep that plan you've got in place when you get out. See if you can get back on the right track, okay?
Thank you, Your Honor.
Oh, man.
Hang on, Mr. Lamont Green. Just hang on a minute. Go on.
This is a different Green. Don't worry. He's calling a Green, but it's not the other guy who we are waiting for him to call back because of his hernia. This is a different Green. Yeah, this is Indiana. This is Elkhart, Indiana. Make better choices. He doesn't have a choice now. He's on the phone trying hard for the other Green. He's still trying to figure out that surgery for this other Green, which is crazy because he doesn't do that, and like that's not part of the law. So it is crazy that he's doing this, but I think he's doing it because he had a hernia before. Remember, he said that he had a hernia before. I'm gonna bump it ahead just a touch. I'll be right back, guys. 1 second.
.1 1511 F346 State of Indiana versus Lamont D. Green. Mr. Green, raise your right hand. Do you swear or affirm under the pain, space, of perjury that the testimony you're about to give will be the truth?
Yes.
State your name for the record.
Lamont D. Green.
Thank you. Show the defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney, Chief Deputy Public Defender Bridget Faulkner, State of Indiana, in court by Deputy Prosecuting Attorney Don Pitzer. Give me a moment. Yeah, this is coming on for dispositional hearing. Just give me 1 moment, please. Okay, Ms. Faulkner, you want to talk first, please?
Thank you, Your Honor. Your Honor, as you are aware, Elkhart County Community Corrections has filed an eligibility report saying that they are willing to, once again, supervise Mr. Green. The violation was because of a lack of progress in moral recognition therapy. Mr. Green and I discussed issues with that therapy at length, and what became clear to me after some prodding is that this was a situation of pride goes first before a fall. Mr. Green has some reading difficulties that he was not sharing with the supervisor of the group. So he was not having a very difficult time understanding and progressing through the materials. He now knows that he has to progress through these materials and he has to ask for help and assistance in doing that. And he expresses to me the desire and willingness and readiness to do that. He does still have a job waiting for him at Flexible Concepts. At the time, he was working third shift, was getting off at 7:30 a.m. and then trying to go to class at 9 a.m. I suggested to him, and I'm not sure if this is possible, but that he inquire whether or not there might be a class that might better suit his sleeping schedule, because that certainly only added to his difficulties in progressing through the class.
He was on home detention too, wasn't he?
I believe so, yes. But I would ask the court to return him to Elkhart County Community Corrections so that he can.
Will be determined, but I'm thinking, wouldn't it suit him better if he was in work release as opposed to home detention? And the reason I say that is because then some of that scheduling and some of that Elkhart County Community Corrections is going to have to make certain that he's in a position where he can go to the MRT classes and also work. It wouldn't be just left up to his devices is what I'm thinking, or his scheduling or lack thereof. Just weigh in on that because I got to make the decision.
I certainly understand your thoughts on that, Your Honor. But I'm not sure that Mr. Green was aware that that was something that he could ask for or that he could make.
I'm going to talk to him at the end of Mr. Green. Listen up. At the end of this, I'm going to give you a chance to give me a statement. I'll be candid. I got questions I want to ask you, so I'm going to give you a talk. Even if you say, Judge, I don't have anything to say, you're going to end up talking, young man. I'm just telling you that you're going to end up talking because I got specific questions I want to ask you.
Okay.
And it's to your benefit to do so because I'm telling you flat out. I think I told you this last time. You don't kick this thing over for dispositional. I was going to put you back at the Indiana Department of Correction. I'm just telling you that. And that's where I'm still leaning. I have to tell you that. So I need to hear from you at the end of all this, okay?
Okay.
All right. Ms. Faulkner, anything else you want to say?
No, thank you.
I don't think I've got more questions for you. I've got questions for him. Mr. Pitzer, please.
May I ask Ms. Faulkner?
Just so you guys remember, I don't know if you remember or not, but Bridget Faulkner and Pitzer, I can't remember his first name. So I show a lot of other Indiana courts here. And those are two people that we see constantly visit the other judges in the other courtrooms. So if you remember them, next time you see another courtroom in Georgia, you can say, oh, I remember her. There's Bridget.
Faulkner, a question.
Sure.
Can you remind me or let me know what the current recommendation from probation is?
The recommendation from Community Corrections originally was that his placement be revoked and he be returned to the Department of Corrections. They have since filed a report saying that they would be willing to supervise him.
They'd be willing to take him back. He's eligible for both a home detention or work release, but they've specifically requested, and I'm not sure. I think they think this is a lot more important than I do because I originally ordered him to follow anything that had to do with community corrections. So he knows he was required to do that MRT. I don't think he's ever argued that wasn't the case.
And he was attending, he just wasn't progressing.
Right, yeah, exactly. And the last line of it is ECCC would recommend he be court ordered to participate in treatment programming as recommended. Well, I mean, I do that with every single one of the appointments, so I'm not sure what magical, if they wanted more magical language, they should have told me what it was. But, you know, look, Mr. Green, I want to be clear on this. I put you at Elkhart County Community Corrections, you got to do whatever they tell you to do.
Gotcha.
You got, I don't care what it is. They can't be, I don't need that. If they think you need it, you got to go do it. You understand me?
Okay. Yes, sir.
Because you get back in front of me again. I don't know whether I'm going to put you at DOC or not. I'm going to listen to what Mr. Pitzer has to say, but I'm telling you right now, it's going to depend an awful lot on what you tell me. But I'm not going to be. You get if you get one more life out of this time, you won't the next time. You just won't.
Thank you, sir.
Mr. Pitzer, what are your thoughts?
Your Honor, I would stand mute on this.
Okay. Okay, I'm going to give you a chance. What do you want to tell me, Mr. Green? You get to talk first.
Well, I was doing everything by the book. You know, I had trouble reading. You know, I had really trouble. You know, with the MRT, but I was scared to ask for help though. You know, I'm a man. It's like a pride thing. You know, it hurts me. You know, but I had my family help me.
Green, are you over that pride thing now?
Yes, sir. Yes, sir.
Help? Yes?
Yes.
Okay, now listen to me. I don't care if somebody has to read the whole book to you. Do you understand?
Yes, sir.
And here's the other part of it. They use a word, you have got to do with them what you would do with me. If I use a word, a legal word that you don't understand, I'm sure you asked Ms. Faulkner, but you know you could also speak up in court and say, Judge, I didn't understand what you just said. And I'm going to try and use regular language, not legalese, regular language to talk to you.
Yes, sir. Yes, sir.
And I'd like to think I'm pretty good at that. I'm starting to wonder if I am, but I'd like to think I'm pretty good at it. But you gotta tell me you're gonna do that. You're gonna say to the people at Oaklawn, I don't understand what you just said. Can you explain it to me, please? Will you do that?
Yes, sir.
Let me ask you another. You got a place to live?
Yeah, I was staying at the Mission.
That's the whole point of putting you in work release. I must be really candid. That's what I remembered about you. I must be really candid, Mr. Green.
But my job is like 5 minutes away from the Mission. You know what I'm saying? I walk sometimes. I'm a ride on show. I walk to work. I'll be there like 20 minutes. You know.
Okay. I'm listening. I'm just telling you this. Okay. You're gonna live at the Mission is generally not a good plan.
I know. I was trying to find me a nice apartment.
I'm just being candid. A better plan is you're gonna be work release. You're gonna save up. You're gonna save up, and then you're gonna find a place to live that you can live and afford, and you're not relying on the Mission. And part is I certainly understand that you can get in trouble at work release, but stuff happens at the Mission. I mean, they're doing the best they can to make it a safe place for someone to reside, but I'm just telling you, time and time again, stuff happens at the Mission.
Yeah.
And you get yourself in one of those positions, you know, you're going to be back in front of me, and then I won't have any choice.
Yes.
You know, what else did you want to tell me? I got some of my questions asked. What else or answered? What else do you want to tell me?
I'm ready to get out of here and go back to work and go to my classes.
Okay. Which one do you want? Work release or home detention?
Home detention.
You gonna make it through it?
Yes.
He's got a while to do yet.
He's got 253 days left, actual days by my calculation.
Less than a year. He's got way less than a year.
253 days.
Less than a year.
It's way better. I don't know what that is, Nan.
Give me a moment, Mr. Green.
Yes, sir.
Better thank Ms. Faulkner, because I'm telling you, saved you from going to DOC. I'm telling you that. Flat out, I'm telling you that.
Thank you.
If you would have got disposition last time, you'd be at DOC right now. Well, maybe not. Maybe you'd be in jail getting credit for DOC, but you wouldn't be getting out, I can tell you that. Cause coming on for dispositional hearing on violation of Elkhart County Community Corrections. Defendant appears in person from the Elkhart County Correctional Facility via WebEx and by his attorney, Chief Deputy Public Defender Bridget Faulkner, State of Indiana, in court by Deputy Prosecuting Attorney Don Pitzer. Court hears arguments from counsel. Court hears a statement from the defendant. Court now returns the defendant to alternative placement at Elkhart County Community Corrections for the remainder of his 2-year sentence to the Indiana Department of Correction. Court recommends the defendant be placed at a level to be determined by, court orders that the defendant be placed at a level to be determined by Elkhart County Community Corrections, but the court recommends home detention. Elkhart County Community Corrections ordered to transport the defendant from the Elkhart County Correctional Facility to Elkhart County Community Corrections. Defendant ordered to have an addictions evaluation and follow up with any recommended treatment. Defendant ordered to complete the MRT course. Defendant ordered to complete any and all other programming as required by Elkhart County Community Corrections. Defendant given credit for having spent 294 actual days in custody plus good time credit per statute. Bond defending is released. The appointment of the public defender's office is ordered withdrawn. The order of commitment is entered, and the defendant is remanded to the sheriff to carry out this order. It is so ordered. So, Mr. Green, I'm going to have Elkhart County Community Corrections transport you from the jail to their facility. Then you'll have to talk to them about whether they're going to get you to the Faith Mission or whether you're going to have to get transportation there. I think they may assist you and deliver you there once they get you set up. Okay.
Okay.
You're going to get released. I have to get the order done, but they also have to get the order and come and get you. So it's going to be on Elkhart County Community Corrections when you're out of the jail. Okay.
Okay.
Good luck to you, Mr. Green.
Thank you.
Judge does not like that he lives at that mission, and he's not wrong.
Yes, sir.
Missions are hard to live at. There are
Thank you, Your Honor.
bullies there, people stealing all your stuff. It's hard living there.
You did keep him out of prison. I'm just telling you.
Thank you.
You hear what he said to her? You did keep him out of prison. I'm just telling you.
Ms. Gushwa, are you there?
Yes, here I am, Your Honor.
Give me a moment. There it goes. Twenty CL1 2109 F230 State of Indiana versus Melissa R. Gushwa. Ms. Gushwa, raise your right hand, please. Do you swear or affirm under the pains of perjury that the testimony you're about to give will be the truth?
Yes, Your Honor.
State your name for the record, please.
I'm sorry?
State your name for the record, please.
It's Melissa R. Gushwa.
Thank you. Put your hand down. Show the defendant appears in person from the Elkhart County Correctional Facility via WebEx and by her attorney, Chief Public Defender Bridget Faulkner, State of Indiana, in court by Deputy Prosecuting Attorney Don Pitzer. This matter comes on for hearing on alleged violation. And Ms. Faulkner, go ahead.
Thank you, Your Honor. Ms. Gushwa, you had indicated to me in our previous appointment that you were prepared to admit the violation, but I also got a jail ATM message from you saying that you had some questions. Unfortunately, I wasn't able to keep our Securus visit because I was stuck trying to get home in the weather situation. Are you prepared to move forward today, or would you like to talk to me one more time?
No, I'm prepared to move forward.
All right, then she is prepared to admit the violation, Your Honor.
Hold on, Ms. Law. Before this court can accept your admission, I must be certain you understand your legal rights. The state must prove any alleged violation of probation by preponderance of the evidence. You're entitled to have a trial in open court just as you're having right now. You're entitled to be represented by an attorney at all stages of the proceeding, just as Ms. Faulkner is representing you now. You're entitled to confront and cross-examine any witnesses that testify against you, and you're entitled to subpoena witnesses at no cost to testify on your behalf. You're entitled to remain silent as it relates to new criminal charges. As to all other matters, you can be called to testify against yourself. Are you telling the court that you understand your legal rights, you're waiving those legal rights, and you're admitting that you violated probation without a trial?
Yes, Your Honor.
Factual basis.
Thank you, Your Honor. Ms. Gushwa, you were serving a commitment to Elkhart County Community Corrections under this cause. Is that correct?
Yes.
And is it accurate that you violated the terms and conditions of your placement there because you went to a meeting of Ready Now on Thanksgiving Day that was not on your schedule? Is that correct?
That is correct.
And you acknowledge that the violation of your placement on community corrections is...
I'm really, really sure, but I'm not 1,000% sure. Ready Now meeting she's talking about is for treatment. It's like Alcoholics Anonymous or some kind of treatment meeting.
It's also a violation of the probation terms, even though you hadn't technically started probation yet.
Yes.
Nothing further with respect to a factual basis, Your Honor.
Mr. Pitcher, any questions?
No.
I watch the Three Stooges every day. It's my son. He is all three of them. I watch him every day. And I wonder, how did you make it 22 years, sir? Come on, Judge. I'm going to bump it forward just a bit.
Good, Ms. Gushwal, because
Yes.
you're kind of in the same boat Mr. Green was in. So Ms. Faulkner and I may look at this differently. So you need to talk. Go ahead.
Okay, yes, Your Honor. I understand. I believe when I came home, I had a hard time transitioning home from prison. I believe I should have never went straight to house arrest. That's where I went. I went to house arrest when I first came home. I believe I should have probably went to a sober living home or should have went straight to work release. I when I came home, like I said, I had a hard time transitioning. It was very difficult for me. I was diagnosed with breast cancer, so I had a period of time where I couldn't even work, and I was fighting the breast cancer. I had.
Okay, now I understand. I played you the wrong clip. All these pauses we're seeing, I edited those out. I played the original clip instead of the one that I edited out. I definitely took this whole part out. I cut it all out because I didn't want one particular vibrator to have to hear it. And then I played the original docket instead of the docket that I clipped. I'm so sorry, guys. I'm stupid.
To have a partial mastectomy. We didn't know whether I had to have, radiation or chemotherapy. I went through about a 7-month period of time where I couldn't even work. Once my oncologist released me from that, I was placed into work release because I was so far behind on payments. Being placed into work release was a blessing. It helped me regain my stability again. I became a functioning human being again. I was able to gain employment, and for the first time in 15 years, I was able to function as a sober person again. And that's amazing. I want to be a sober person. I'm very active in my recovery. I've had a few relapses, and I acknowledge that. The people at work release, my caseworkers at ECC have been amazing and very supportive with me. I'm very active in my recovery. I just challenged myself to do 90 meetings in 90 days. No one's ordered me to do this. I want to do this for myself. I have a job. My boss is very supportive in my recovery. I changed.
Where are you going to work?
I work at 7-Eleven. I know it's not an amazing job, but it's a job I love. It's my first job I've had, a legal job, a good job that I've had.
Lady, if someone is making fun of you for working at 7-Eleven, send them my number. There is nothing wrong with working, period. Point blank, period.
15 years. And my boss is amazing to me, and he's holding my job for me. I get to go back, if I get to go back to work release, he's waiting for me. So, he's even willing to help me get a car, I have amazing supportive people in my life now. Sober people. Since I've been to work release, I have a sober connections that I've never had, sober friends. I graduated IOP. I'm in aftercare now. I have a peer recovery coach. I am on mental health medications now that I need to be on. I'm not the same person I was back in September 9th of 2021 when I was arrested on this case. I'm not the same person I was. I am a very different person.
Are you doing your mental health at Oaklawn?
No, I'm doing it with it's Simpson Behavioral Health. Is where I do my I see my behavioral health mental health person, and I'm doing my addictions recovery at ARC, Addictions Recovery Center, out of Goshen.
Okay.
So, I mean, I just have amazing things going for myself now, and I feel I'm just happy. I'm a happy person now.
She went to a meeting. She went to, I think, a sort of like an AA meeting, but she didn't tell probation she was going.
A happy, sober person. So,
Really better. You may not think the 7-Eleven job is amazing, but I occasionally enter into a 7-Eleven, not often, but and when I do, I would much rather have you wait on me than most of the people that I've had at 7-Eleven.
No, Judge, no.
You're at least smiling.
Yeah.
So I'm going to spoil it for you, JK. He does give her a chance, but it's brutal. It's brutally bad. It's not a good idea for her, but it's what she gets.
Or maybe perhaps I'm not smiling. That's why they don't smile back. I don't know. Okay, so I want you to listen to me very carefully now. I'm glad things are going well for you. You look much better than the first time I saw you. I do think that you've made some positive steps, but you need to listen to this. I'm changing your sentence.
Okay.
And I want to be clear on this. So I'm going to revoke, and I'm going to get into this at the end, but I'm going to tell you what I'm doing so you understand it, okay? I'm going to revoke your placement on Elkhart County Community Corrections. I'm going to revoke your probation. So I'm revoking all of it. I'm going to reimpose the remainder of the 15 years at the Indiana Department of Correction. I'm going to place you alternatively at Elkhart County Community Corrections at a level to be determined by Elkhart County Community Corrections, but I'm going to recommend work release, at least to start out. Now, what that means is that you're not, this is not a, the deal you entered into with Mr. Pitzer was 15 years, 5 year deals, 5 years at community corrections, 5 years on probation. I put you at DOC, I put you in RWI, I modified you out to Elkhart County Community Corrections. So I've already modified it to a certain extent, but what you need to understand is that's gone now.
Okay.
What you have now is 15 years to the DOC with whatever's left of the 15 years to the DOC with alternative placement in Elkhart County Community Corrections. You screw this up and you know what I'm going to do. You're going to be at the DOC for the remainder of the 15 years. You got that?
Yes, Your Honor.
So you need to stay on the path you're on with your sober friends and your mental health treatment and your addictions treatment. I'm going to order all that. Okay. You've got a recovery coach. I'm going to order you to have that also. I mean, you're in compliance right now. You just need to get back there and stay on the track you're on. Okay.
Okay.
But I want to be clear. This is not going to be, well, I just have to get to 2028 and then I got 5 years of probation. That's not the way. You want me to do that? I'm going to send you back to the DOC right now. And then you'll have your precious 5 years of probation, but you're going to do the time first up at the DOC, not at Elkhart County Community Corrections. And you should know, you've been in front of me enough. You should know me well enough by now, Ms. Gushwa, that I don't intend for you to do, 5+ years at Elkhart County Community Corrections. I do go to Elkhart County Community Corrections and get a chance to show me that you're really on the right path and that I ought to get you off there and put you on probation. That's what the whole deal is here. Okay?
Okay, Your Honor.
But that's the sanction. That's the only way you're going to get me to go along with this is I now control all of your Miss Faulkner's going to say, hey, don't make too much out of that, Ms. Griswold. He controlled all of it anyways. It's not that big of a deal. I'm just telling you, it is a big deal because I now have revoked everything. So you screw up, I'm just telling you, you're going to go to the DOC.
Okay.
Don't let that happen. Do not come back and say, if I walk into your 7-Eleven, you can even say, hi, Mike, how's it going? You come back and see me, only one of us will be doing well. You got that?
Yes, Your Honor.
I don't think she understands fully what just happened to her right there. And it's bad. It's so bad. If she messes up, a tiny bit. She's already backslid. What did she say? 3 times in the last 4 years? 5 years? 4.5 years. I don't know exactly how long it was. If she screws up the tiniest bit, if she misses an appointment, if she drops dirty, if she does anything, she has 15 years on her head. He's just going to send her there. She lost everything because she went to that meeting. Because she went to an AA meeting. I don't know what it was. Recovery asset or something meeting. Because she wanted to do Department of Correction is prison. DOC is prison. So ComCore is community corrections, which means you get locked up on ComCore. And then they decide where you're at. So they could keep you locked up. They could let you out for work release during the day. But I don't think Elkhart. I think Elkhart does have a work release. My bad. So they can let you out for work release during the day, but you're still locked up. They can give you 1 day out a week. They can help you get an apartment or one of those halfway houses where you're still supervised. You have to come home by 5 o'clock every day. You have to wear a monitor. You could be on house arrest or whatever. They decide your level of, how you should be incarcerated right now. And it could be fully in your own home, or it could be fully locked up. They control you. So it goes prison, it goes ComCore, and then it goes probation. And probation is whatever the probation terms are. So those are the 3 levels that you can get, or jail. There's also a jail not a felony. So she had a 15-year sentence to prison. And she got a deal where she spends 5 years in prison, 5 in community corrections, 5 in probation. And, she gets good time, so she got out of jail, 3.5 years or whatever. I'm not going to pretend I know what kind of good time she got, but let's just pretend it was 3.5 years. And then she went on community corrections. And all she had to do was make it 2 more years till she was on probation. And she messed up because she was on an ankle monitor and she wasn't where she was supposed to be when she was supposed to be there. She was supposed to be home or something. Jail and prison are not the same thing. Jail is jail. It's for more like misdemeanors. It's like kindergarten. And then prison is like high school. So you're not in jail for 40 years. You wouldn't get a 40-year sentence to jail. You would get, a 40-year sentence to prison. So once you go to the Department of Corrections, that's pretty bad. It's felony bad. So yeah, jail is easy. Well, it's not easy. I don't know. I've never been to either. but we've seen a lot of court here, so we know jail is easy. That's why we see a lot of cases sometimes where the judge will let them finish out their sentence in jail instead of going to the Department of Corrections. They get to finish their sentence in jail because they had a misdemeanor of whatever, domestic violence, and they got a year in jail for that. And then they pick up a felony that's only 6 months of prison. And the judge will say, well, okay, you can do that prison time in jail. We'll let you do that. So she has 15 years of prison hanging over her head. And if she so much as looks at a vape pen, she's going to prison. So I don't think she's smiling right now, but she's screwed. She got railroaded during this hearing. And I feel bad for her. But, if she doesn't break the law and her terms of community corrections, she'll be okay. It's hard because I think probation and community corrections are designed to make you fail. Like, they make you wear an ankle monitor, which costs $10 a day, or they make you drop. They make you take drug tests, which is $10 a day. And then to get that money, you have to go to work. But if, let's say you're driving to work and the road is closed because a tree fell over it, and you got to drive around to a different block to get to work, boom, you're in violation. You're in violation, and you were just going to work so that you could pay for the ankle monitor and pay for the testing, and then you fail. And there's nothing you can do about it. I just think that, you know, I'm glad for probation, don't get me wrong, and I'm glad for community corrections, do not get me wrong. I just think it is designed more so to have you fail than succeed. But remember, guys, you got to remember, when we see people who have violated probation, or I should say it this way, we only see the people who have violated probation. We never see the people who have succeeded. So we see judges every day put people on probation. And then every day we see people who have violated their probation. So it would make sense to think, well, probation doesn't even work. Everybody violates. Yeah, everybody that we look at violates. Because that's all we're looking for. I play clips of the people who violated. If I played clips every day of the people who succeeded in probation, none of you would stay here and watch 2 hours worth of this. You know what I mean? I have some so good, heartwarming stories that come in front of these judges, and their lives are changed, and they did so well. Yes, and then I can never play them. I can never play them. Nobody would sit and watch. Nobody would sit and watch. But we only see the people who fail. Way more people succeed on probation than fail on probation. Probation changes a lot of people's lives. People who were doing bad, now they're doing good. So it does work. All the people who succeeded on probation are in my chat. But yeah, but do try to remember that. It's so easy to see. It's so easy to see everybody violating probation over and over again every night and think that probation just sucks. It doesn't work. It does. We just don't see those. We see the bad people. So when you see a judge that is giving out probation instead of sending someone to jail, it's because he's seen it work over and over and over again already. So there is a chance it's going to work. Even though we all know it's not, we know she's going to go to prison. Unfortunately, she's going to go to prison. I don't know what yes, I do. Her original crime was dealing. She was a drug dealer. So, yeah, we can't laugh at success stories. So I can't play them. But the judges see them. So when the judge puts her on probation, which he didn't, he knows there's a chance she'll make it. When we know there's no chance in hell she's going to make it. She's going to mess up somehow. A tree is going to fall down tomorrow. And that's completely out of her control, and it doesn't matter. And this is why it doesn't matter, because she just violated. So she can't come back in a month and say, oh, it wasn't my fault, when she was here and saying, oh, I made a, she can't make a mistake over and over and over again and expect the judges to keep saying, oh, yeah, that sounds legit. Oh, yeah, that's a mistake. Oh, yeah. No, they don't do that. He definitely, this man definitely won't do it. Yesterday's stream, I showed a guy or a girl, I don't remember which one it was, 40 failures to appear just in 2025. If this judge gives you one, that's crazy. If that person was in this court right here, that person would already be in prison. There wouldn't be 40 failures to appear. Maybe one. Maybe one. Not two. Not two FTAs, not in front of this judge. But I don't play this judge a lot because what you heard is every single docket. And after a while it gets monotonous. So I sprinkle him in. He's so good every once in a while. But Judge Fish, he's one of my superstar favorites. You can only watch him on this channel. And I've been showing him more. He is excellent. Judge Eric Johnson is so good. From Colorado, he has not streamed in January. My fingers are crossed. I know that he wasn't in court. And the reason that I know this is because 5G took over his docket, and they say things like, this is from 4G. These cases are from 4G. And some of his lawyers are over in 5G. And 5G was like, man, we had 60 cases today. And the lawyer's like, well, that's half of a docket in 4G. If I was back in 4G, we would have hundreds. And it's true. He does 100 people a day on his docket. And he is amazing. He's so good. So hopefully he comes back soon. Judge Caulfield in Georgia is so good. He is just an old, cranky, slow judge. He has not streamed all January. A lot of Georgia has not streamed all January. I don't remember his name. I think his name is Wilson or Williams. It's the other judge that we always see down there, but I can never remember his name. Nope, haven't seen him all January. So I'm hoping that now that it's February, I'm hoping our judges come back. I'll get more Meredith. I did get some cutie pie. I did get some more cutie pie, and I think I got a good piece. That's probably coming up this week sometime because I just really love him. But we got some good judges coming up this week, and we got some good cases, and you can only see them here. So make sure you subscribe. Thank you so much for coming out to an evening live stream, which is crazy. In about 6 hours, we're going to be live streaming again at our normal time slot, which is 4:30 a.m. Eastern Standard Time every day except for Sunday. So, Eileen, I hope you're sleeping well. Don't wake up, Eileen. Guys, we have a few more days of OJ left, and then the OJ trial is good. So, done. So I'll see you guys tomorrow morning for a regular stream, and then the OJ stream. Thank you so much for coming out. I really, really appreciate it. John, thanks for the raid. You're awesome. You're amazing. You're a superstar. Bill, if you're still listening, love you bunches, and give Emily a big kiss for me. Have a great night, guys. See ya. Thank you. This is my favorite part, Jude. Jude made this song for me. You ready?
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.